Good evening and welcome to this episode 32 of our From the Horse's Mouth podcast from the South African Equestrian Federation. My name is Georgie Roberts, and this evening I am talking to Tracey Lomax. We're discussing contract clarity. Sam Goldwyn famously said a verbal agreement isn't worth the paper that it's written on. So we're going to delve into all things legal as we discuss not only contracts with Tracey to help clarify the muddy waters around these things, but looking into lease agreements, livery contracts, sales agreements, and more. Let's discover the legal pitfalls of buying and selling horses under the South African law, as well as public liability implications for yards, owners, and instructors. Please remember that this is your opportunity to procure some excellent legal insights for free, courtesy of our very impassioned legal experts. So please leave your comments in the comment section. Tracey, thank you for joining us tonight and taking time out of your busy schedule. I know you are a very committed equestrian, so thank you for giving us your time.
Thank you, Georgie, for having me.
So, Tracey, I think kicking this off perhaps with the buying and selling of horses is a good way to begin before we move on to discussing livery, leases, and public liability. So it's interesting because we've had this discussion before on the podcast from a veterinary aspect of buying and selling horses and what needs to be disclosed. But from a legal perspective, what are some of the implications that buyers and sellers need to be aware of?
Okay, the first thing I think, a very common misconception a lot of people have, and it's one thing I want to dispel from the outset, is there's this perception that it's only a contract if it's in writing. Oh. And that is just not true. Our law recognizes oral agreements, often called verbal agreements, which is a misnomer because verbal means by word, which is written or orally, but that's just me being a grammar nerd. So our law will recognize a written agreement, it will recognize an oral agreement, and it will even recognize a tacit agreement, which is where the conduct of the parties is found to demonstrate that there has been an agreement, even if nothing was actually said.
So I think it's quite important. Hands, Tracey, like would that fall under a tacit agreement?
No, well, yes, it could, but not necessarily. Sometimes a tacit agreement takes place because the parties conduct themselves in such a way that a court finds that it's quite evident that both of them understood what their mutual rights and obligations were. So it doesn't even have to be, in other words, what I'm saying is that not every agreement requires a formality. Okay. There are certain agreements in law which by law require formality, like the sale of land. A sale of land is only binding if it's in writing. There are certain others that are sort of regulated by legislation, but within the horse riding industry and the agreements that we're going to talk about today, I think it's important for people to realize that the fact that it is not in writing does not mean that the agreement which was concluded is not binding. The importance of reducing something to writing is that you can prove what was agreed. And that is so often overlooked, especially in an industry like ours, which is quite small. So we all do this. We all go out for wine and we conclude an agreement to sell a horse or lease a horse or stable a horse or breed a horse.
Or we accept payment for legal services in the way of.
Oh, we do that too. Yeah, we do that, but we don't talk about that. And people then go away and behave based on their understanding of the agreement. And 6 months down the line, everybody hates each other. Everybody is a crook, and you can't trust horsey people. And there's a palaver which winds up in court, and that can often be avoided by written agreement. And I always tell my clients to be a little bit skeptical of people who won't reduce agreements to writing. I don't care if you're sleeping with them, married to them, or about to bear their child. If they're reluctant to put something in writing, you should perhaps reconsider your relationship. But that doesn't change the fact that agreements do not have to be written in order to constitute agreements. And we hear this all the time. Somebody will come to me and go, oh, well, there was no contract. And I'll have to say to them, well, actually, there was. There was an oral agreement. And we know this because you have behaved in terms of what you understood that agreement to be. So that's quite important to remember from the point of view of of be careful what you commit to, and be careful what your behavior says about your understanding of the relationship. So that's just an initial. So basically, what you need for a contract of any kind for our purposes is, firstly, it needs to take place between two people. You don't have an agreement with yourself. So you'll have two or more people concluding an agreement. You have to have some kind of mutual understanding of what the terms were. And the courts interpret that objectively and subjectively. In other words, they look at what the parties say they believe the terms were, and then they look at the way the parties behaved, and they go, well, actually, it's quite clear that you thought these were the terms. Mm. If the terms are not clearly set out in an agreement, then the court will still enforce an agreement where the terms are ascertainable. In other words, if you don't agree on a price for something, but you sit over a glass of wine and you go, you know what, I'll sell this horse to you for the same price as I get for its brother. That's an ascertainable price. That's an enforceable term. So you know, what I'm saying is there's a lot of space. Courts don't like to lightly set aside arrangements between people.
Okay. So basically, Tracey, like the takeaway is that you should behave with integrity throughout this. People should have contracts written down. It's just for clarity's sake. But how you behave does, and what you say does count. You can't discount that.
At the risk of sounding like a lawyer, I'm always a bit loath to bring in questions of integrity and morality, because generally where these things fall apart is not because one person is inherently less honest than the other. They fall apart because, as with most things in life, shit just happens. And misunderstandings happen and relationships fail. And one party understands that the agreement was subject to certain conditions, and those conditions aren't met. So yes, I think ideally we want to live in a world where we can trust the integrity of the people we're dealing with, but it's yet another reason to put things in writing, not just because you can't trust integrity, but because misunderstandings happen all too easily. And a good contract will make provision for what should happen if certain events take place.
So what constitutes a good contract, Tracey? What are the elements that people need to, like, for example, is there a blueprint that they could find online to kind of guide them? Or what are the important elements that need to be covered?
Okay, so every type of contract has certain elements. So for instance, a contract of sale, you need to have the subject of the sale needs to be identified or identifiable. The price has to be identified or identifiable. The buyer and the seller have to be identified or identifiable, and the seller has to have the legal authority to transfer ownership. So, you know, if I go and I buy your horse from somebody else, that's not an agreement of sale which can be enforced, because that person doesn't have the legal title to enforce it. When it comes to lease agreements,
I just want to put a pin in that.
Yeah.
That's interesting for me from a dealer perspective. So your agreements of sale still has to be between the original owner of the horse and the new owner. It can't be through a dealer, because they
no, not necessarily. There's various ways that sales can happen. So when it comes to dealers, you can have a couple of things happen. You can have a back-to-back agreement where the dealer says, I'll take in the horse. When the horse is sold, I will pay you X amount of money. So the dealer gets paid, the dealer pays the seller. And ownership is transferred from the seller to the dealer to the buyer in a back-to-back arrangement. You can also have arrangements where the dealer is the agent for the seller. So in that instance, the dealer has authority given by the seller to sell the animal, and ownership is transferred as a result of the authority which the agent has to transfer ownership.
Okay. Okay, so
yeah.
Okay, so we've got, so you have to cover who the parties are, the sale price. What I think it's, I'm interested to know some of the pitfalls people might be getting into when it comes to these conditions that you're saying subject to.
Okay, so where things often go south, or in my experience, where things often go south is where what the buyer thinks they are buying and what the seller thinks they are selling are two different things. So the seller gives the horse to the dealer. Oh, well, look, we all know it's a horse, but there are horses and there are horses. So the seller gives the horse to a dealer and says, I want you to sell this horse for X amount of money. The seller makes full disclosure to the dealer of every veterinary issue the horse has had, whatever vices the horse has, what the horse's performance history is, etc. A dealer may not pass on those disclosures to the buyer.
And should those be disclosed in every sale, Tracey?
Yes.
Okay.
Yes, they should. And if the dealer fails to disclose them, the seller could still be liable for misrepresentation in as much as that dealer has what we call in law ostensible authority. In other words, the buyer has every reason to believe that the dealer has the authority of the seller, and in those instances the dealer steps into the shoes of the seller. So whatever the dealer doesn't do, the seller is deemed not to have done.
Okay. So again, it comes down to make sure that you've communicated clearly with your dealer and that they're representing you accurately.
And I'd encourage any seller to have a written contract with the dealer, a written contract of agency in which the seller makes full disclosure to the dealer of any defects in the horse, every issues with the horse, and the dealer acknowledges and commits to disclosing all of those things to the buyer. That way, if the buyer does come back to the seller and asks either for a reduction in the purchase price or a cancellation of the sale, the seller would find it much easier to have recourse to the dealer.
Okay. Tracey, I know in certain, and this is maybe not a legal question per se, but it's just one that I think is perhaps good advice for people. I know in certain European countries, if you want to sell a horse, you as the owner are obliged to do a veterinary check on this horse, so that you are, and that ties in with, I think, with their law, so that you obviously can't disclose a fault that you're not aware of. But that's probably a good starting point for sellers.
Yeah. So what you have in any kind of sale is you have latent and patent defects. A patent defect is a defect which is obvious, and therefore which the buyer should either is aware of or should be aware of. So in other words, if the horse has 3 legs, the buyer can't complain that the seller hid that the horse has 3 legs, to use a ridiculous example. Then you get latent defects, which are defects which to the non-expert buyer are not obvious, which would require experts to ascertain.
Okay.
If a latent defect is known to a seller, in other words, if a seller has had x-rays done and it turns out that the horse has navicular disease, the seller should disclose that. That is a latent defect which a buyer is entitled to know. We all try and rely on the footstoots clauses, but the Consumer Protection Act has closed a lot of those holes, especially when the horse is being sold by a dealer.
Okay.
Because a dealer is in the business of selling horses. They don't get to hide behind footstoots clauses all that easily. And you especially don't get to hide behind a footstoots clause if you know of a defect and you hide it. So if you drug the horse, nerve block the horse, whatever you do to mask that, you're going to find it very difficult to get out of responsibility for that.
So if as a buyer you've bought a horse and something lands up going not as a result of you, but you discover something about the horse after transfer has taken place and after money has been paid, legally, is there recourse for you in South Africa to go back and get your money back and return the horse?
Okay, so let's talk about a few things. So firstly, let's talk about when ownership is transferred. In South African law, ownership of a movable thing is transferred when delivery takes place with the intention of transferring ownership. And that's quite important to remember, because there's an awful lot of people who are quite happy to hand the horse to the buyer before payment is made. And then when payment is not made, they suddenly want the horse back because they say they're still the owner. If you have not specifically reserved ownership pending payment, you lose ownership of that horse.
Geez, that's
so
a hell of a footnote.
It's quite a big thing, that. So if you're involved in a sale and payment is in installments, but the person is taking delivery of the horse, it's really important that you reserve the transfer of ownership until the final payment is made.
Okay.
But getting back to your question, once payment is made, and you find out that the animal, in other words, this is why it's important to know what the subject of the sale is. If you believed you were buying a horse that had the capacity to jump 1.20 meters, a horse that has the capacity to jump 1.20 meters has to have certain physical capabilities. Let's leave aside whether or not the rider can do it. Let's just look at what the horse is objectively capable of. If you suddenly find out that the horse actually has a fractured pedal bone and is never going to jump more than a pole on the ground, there's no sale. Because what you thought you were buying is not what you were in fact given. So you then have a right to cancel the sale and claim your money back.
Okay.
The alternative, if say the horse has a splint, which is treatable, you can claim a reduction in the purchase price, because had you known about the splint, you would have paid less money. Or you can claim the cost of removing the splint. So there's various ways of getting recourse, and what it is you want to achieve is going to depend on what the court's going to say to you. Had you known at the time, what would you have done? Would you still have bought the horse?
Okay.
Would you have paid the same amount? Would you have insisted the owner remove the splint? And it'll then make a finding based on that.
And Tracey, what's the correct way to go about this legally? So before we go and get, which the horse industry is sometimes known for, before we leap into litigation, what is the best? So obviously the best thing is, hopefully you've got a contract, you go and you approach the seller and you say, look, according to the contract, from there on, if assuming that the seller says no, footsteps clause, this is up to this is your poor luck, what is the next step legally? Do you invite them for mediation? How do you proceed?
Look, I'm a fan of mediation. I'm an accredited mediator myself, so I believe in the process. Not a lot of attorneys do. There's a lot of attorneys who think mediation is a complete waste of time, and I think a lot depends on the caliber of the mediator. Mediation is relatively inexpensive because it's just the two parties sitting with the mediator and they share the costs of the mediator. It is generally without prejudice, which means that whatever is said can't be used against you. And I think where the quantum involved is not massive and the relationships involved are worthy of salvaging or saving or restoring, mediation is a good way to go about that. So I often encourage my clients to look to mediation rather than litigation. Litigation is acrimonious. Many attorneys are assholes. And there's many
It's so
attorneys
ironic
who
because I was going to say
that's
this
it
about
is a little.
I'm joking. I'm joking.
Well, can you imagine horsey attorneys? But so the problem with litigation is that there is a financial investment suddenly.
Okay.
And that means that it becomes a little bit of a war of attrition. Once you are down the road to a certain extent financially, it becomes much harder to start stepping back from your position and going, you know what, maybe we should take an economic decision. So yeah, mediation is a good idea. Litigation is another possibility. Arbitration, I'm a big fan of arbitration because I probably shouldn't admit this publicly, but I'm slowly losing faith in the courts. And arbitration is quicker, but it is more expensive.
Okay.
I honestly wish that SAEF and the disciplines would create a portal for the resolution of disputes, almost like an ombudsman system.
Oh, that's interesting.
I think that our sport has enough disputes. I think that the disputes are of a sufficiently large sort of financial cost that the creation of a portal like this would benefit the sport. And I think our sport is small enough that we really shouldn't be encouraging our members to like plant any flags on any hills. Yeah.
Well, I think you've said to me before, you know, when the elephants fight, it's the grass that gets damaged. And I think that's definitely the case here. So just to wind up the contract elements before we move on to your and my favorite discussion, the contract and what it should cover. Any of those other clauses, Tracey, is there any way you can reasonably protect yourself against every eventuality? Of course not. But what do you include?
Okay, I think what you need to do is the parties need to be properly identified. And this sounds really obvious, but it's not always.
Okay.
Because, you know, if the horse is registered, for instance, in the name of a 16-year-old child, that doesn't make the 16-year-old child the owner.
Okay.
So the parties have to know who is owning this horse, who is buying the horse. Is the horse being bought in a partnership, in a syndicate, by a sponsor, by a company? It's really important that the parties identify themselves, because I cannot tell you how many times I've gotten 3 weeks down the line and I've had to say to my client, well, it's nice to know you, but actually you're not my client. You need to identify the horse. So if what you are buying is a particular horse with a particular name, put the name in. If what you're buying is a foal that is expected to be born, identify that foal so that, you know, in 18 months' time, if there's any doubt as to whether this is the foal you bought, you can look to the contract and say, well, this is the foal I bought, this is the stallion, this is the mother, you know, this is the foal I bought. Know the price. Put the price in. If the price is being paid in installments, include when those installments are payable, whether there's going to be interest on those installments. And this becomes important because suddenly you start looking at National Credit Act implications. So that's quite important.
That's interesting.
And also what conditions there are, whether they are what you call suspensive or resolutive conditions. In other words, if the sale is subject to the horse vetting sound, specify what you mean by that. What do you mean by the horse vetting sound? What is it that you require the vet to confirm is able to do? If there's a resolutive condition, in other words, you're buying a mare subject to it being in foal, by when does the mare have to be in foal? Those are all things that need to be specified in the agreement. And, you know, agreements don't have to be complicated. It's not rocket science to draft a contract. It just has to be a contract which is easily understood and easily interpreted.
I think it was Einstein who said, if you can explain something simply, it means you understand it really well. And that's exactly your point, what we should really go for. Okay, so
Yeah.
Tracey, something which is a personal bugbear of mine, and I was so excited when you brought it up, commission.
Oh, yeah, my favorite. Okay, so in terms of our law, and this is going to piss off an enormous number of people.
Before we go down there, can we just, because sometimes we get people who aren't familiar with this concept. Commission would be if somebody assists with the sale of a horse, they get a percentage of the agreed on purchase price subject to sale, correct?
Well, commission can be anything. It can either be a percentage, it can be an agreed figure. It is a reward for facilitating a sale.
Okay. So who should, so carry on, sorry, I interrupted you.
Now the issue with commission, and this is the problem I have with horse sales, is in terms of our law, you're not entitled to commission unless to earn commission, you're an agent. To facilitate a sale, you're an agent. You're either an agent for the buyer, or you're an agent for the seller, or you're an intermediary agent, which brokers between the two. But to be entitled to commission, you have to prove that there's an agreement to pay you commission.
Okay.
Again, it doesn't have to be in writing, but there has to be an agreement to pay you commission.
So the buyer or the seller have to be aware of the fact that they're being charged a commission.
One would hope so, yes. And this is where so often it doesn't happen. A seller is told that the horse is being sold for 300,000 Rand, and therefore the seller's instructor has to get 30,000 Rand, the buyer's instructor has to get 30,000 Rand, and the person who sat at the pub and told the buyer's instructor about the seller's instructor's horse gets 30,000 Rand, and you've suddenly got 90,000 Rand commission on a 300,000 Rand horse. And it happens. And it's illegal.
Yeah.
And I would go so far as to say it's fraudulent.
And
you
sorry, carry on.
Yeah.
So
you can't go around charging for something that nobody has agreed to pay. And you can't go around charging commission when the agreement in terms of which you are claiming that commission is silent on the issue, and where you're not known to the seller, and in some cases not known to the buyer. And I've seen instances where instructors arrive, bitch about the horse, and then half an hour later phone the seller and go, well, is there commission in it for me? And when they find out that there is, suddenly they rave about the horse. It's absolutely criminal what happens.
Is there any way?
It shouldn't be happening, and buyers and sellers should be stopping it.
Is there any way to legislate it? Because I understand the flip side of it is like often you spend months looking for a horse for your pupil or whatever the case may be, and that's the agreement. That when you find the right horse, you're not going to be paid for your time looking for this horse and making phone calls and everything. But you're saying that needs to be very clearly clarified between the agent per se, whoever that might be, and the buyer at the time. And they agree that that's what the deal is, and then it's going to be X percentage. The same would go, sorry, yes?
No, I don't think it needs to be legislated. It's an accepted part of our law. Okay. Our courts have held that this is the case. And I think it's dealt with in the Consumer Protection Act. I think that the answer is education, is saying to people, when you put your horse on the market, tell the person you're putting the horse on the market to, this is the commission I'm paying. This is the only commission I'm paying. This is the price I expect to get. And if you intend to screw me out of any more, tell me now and I'll go elsewhere. And I think what we also should start doing is reporting instructors and dealers who charge commission that they haven't earned. Start reporting them for fraud. They're not entitled to it. Report them to SAEF, report them to SAPS, make life really uncomfortable for them.
And Tracey, when it does come to that, there's no kind of guideline legally for what is and isn't acceptable. It's whatever's agreed on between the parties.
Yeah, and I mean, there are times when there's a lot of work which goes into selling a horse. There's a time when the horse stands excuse me, it stands at the dealer's yard. The dealer incurs the costs of keeping the horse. The dealer incurs the costs of schooling the horse, taking the horse to shows. I would fully expect that that dealer would be entitled to more than simply 10%. By the same token, if all that has happened is a telephone call, then I think a seller is entitled to say to a dealer, well, please explain why you're entitled to 50,000 Rand on a 500,000 Rand horse. And I think a lot of the problem in our industry is we become a little nervous to raise these issues with professionals and with our instructors and with people in the know, because we're worried about being blacklisted. And again, I think it would help if SAEF or the disciplines created an ombud for this, where people who do this kind of thing often had to face consequences fairly often of doing this. It's the only way to really stop this behavior is by creating consequences for it. And it's a little bit hard to expect an amateur who doesn't know everything, doesn't know everybody, is nervous of being blacklisted to take on a big name. It's hard for them. They need SAEF for one of the disciplines behind them.
Tracey, I do have a question here privately. Someone has said, if there is an agent for the buyer and an agent for the seller, and they've both separately agreed to earn a commission, do they need to then still disclose that to the other buyer? And you know what I mean? Like, do they need to disclose that still to all parties?
It depends on what the agreement is. If the buyer and if the buyer's agent has asked for a certain commission and they're acting for the buyer should pay that commission. So then it should get added to the purchase price, not deducted from the seller's purchase price.
Okay.
If that hasn't taken place, I think it's a bit much for the buyer to expect the seller to take a knock.
Okay.
Yeah. So if you're somebody's agent, your principal pays you.
Yeah. That's lovely. Tracey, so moving on to livery contracts, and I've already got a question about livery contracts, but I think it's for the end. What should livery yards, if we're just speaking now to yard owners, what should they consider including in their contract to best protect themselves?
Okay, so a livery is a service. So basically what the livery, and again, what the service is depends on what is agreed. So some livery yards offer full livery where they assume all the responsibility of caring for the horse at a certain cost. You get DIY livery where the owner provides certain things. So what needs to be included in the contract is exactly what is expected of the horse owner and what is expected of the yard owner. There are certain tacit terms which a livery yard owner needs to be aware of, and that is that if you are undertaking to care for somebody's asset, and in this case the asset is the horse, there is a tacit term that you will do so with utmost care. Therefore, if you do anything to endanger that horse, you can be held liable for the costs of endangering that horse. And I know we have indemnity agreements, and I know we have all these signs up and the rest, but our law has started interpreting these with a bit more jaundiced view. So in other words, if you make your living from looking after other people's horses, and you decide one day to chuck a stallion in with a mare because you actually are drunk by 3 o'clock and don't feel like doing anything more, you can't rely on that indemnity. You have a duty.
So an indemnity won't ever cover negligence, basically.
Sorry?
An indemnity won't ever cover negligence.
No, that's not so. An indemnity can cover negligence. It won't cover gross negligence.
Okay. And what's the difference?
It's decided on a case-by-case basis, but the simplest definition is gross negligence is the kind of thing where you sit back and you go, oh my God, versus, well, that could happen. And a court is going to decide whether it's gross negligence or normal negligence, and it's going to be based on many factors. including what was going on at that particular occasion, because as we all know with horses, there are no accidents. There's just shit we didn't think about.
I don't know if you're familiar, Tracey. There's actually a very, I don't know what the outcome is, but there was a very high profile case recently with a potential Olympic horse bought, and it was in transit at an intermediate quarantine station, or, you know, as a yard. And they've got CCTV footage of the groom leading the stallion while talking on the phone. The stallion is broken loose. Mm-hmm. And basically this intermediate agent, and like I said, I don't know what the outcome is. It'll be interesting to see. It'll set a precedent, I'm sure, because neither the buyer nor the seller wants to be out of pocket now for this, obviously. Sure. So it'll be very interesting to see what does happen in a case like that.
Yeah, and again, you know, just from what you've said, it's hard to tell. He's leading the stallion. Where is he leading the stallion? Was the stallion enclosed? If he answered his phone, was there any reason to believe that he wouldn't have full control of the stallion? Was there any reason to believe the stallion would hurt himself? These decisions as to whether something is negligent or gross negligent are determined by the facts, and it's very, very difficult to write an indemnity clause or contract out of anything that can go wrong, because let's face it, horses are those animals that you can wrap in cotton wool and they will still cut themselves.
Oh, and no, but I read there was such a funny quote the other day. It said, like, basically, if you hate it, it'll live forever. It'll have hocks like iron. And so I really, but as cynical as you are about the law, I think I can be cynical about horses.
I've always said it. If it's going to die of horse sickness, it's probably because it's really talented. If it's going to survive, it's probably a dog. Yeah. Which is horrible, because I know people have lost horses to horse sickness, and I don't mean it, but it's just, yeah.
What rights do liveries have, and what should liveries check in their contracts? And I think this is important to separately check, Tracey, because generally the yards who are constructing livery contracts have been around the block, and they know, you know, what's up, and they've probably had a chance to revise that contract repeatedly. Liveries can often be amateurs who haven't considered all of the pitfalls of such a contract. What are some of the things that they, like, if you get a contract, should you get someone legally to look over it just to be safe? What should they be on the lookout for?
Okay, I think before you even conclude a contract with a livery yard, you need to have an expert go with you to the yard, somebody that you trust, who can look at the yard and go, these are the things that worry me, and these are the things that are good. Because there's not a contract in the world which is going to save you from something you saw and should have known about. So it's really important that anybody who does enter into a livery yard goes in with their eyes open as to what they can expect from the yard owner. Then you need to know exactly what it is that the yard owner is committed to doing. So is the yard owner providing 24/7 supervision? If that is the case, then if your horse colics at 10 o'clock at night, you have the right to expect that colic will be picked up. If the yard owner tells you that the yard is open from 7 in the morning until 7 at night and there isn't supervision at night, you take that risk if you leave your horse there. So it's important to know what the yard owner is promising. It's also important to know what the yard owner expects of you. So and this, when it comes to expenses. So in other words, what is it that your livery covers? Are you covering just feed, bedding, grooms costs, turnout? Are you going to be billed extra for fly spray, for dip, for if the horse cuts itself, for any medication that is given? Are you expected to provide a first aid kit? All of those things should be spelled out in the contract, because the last thing you need at the end of the month is to suddenly get a bill for 3,000 or 4,000 Rand more than you expected to pay. Because you didn't discuss with the yard owner what was included in your livery. So it's really important. And this is where I think yard owners sometimes make the mistake of not hiding the real cost of keeping
maybe horses, assuming,
or being a little bit reluctant to express it, because it's one thing to say my basic livery is 6 grand a month, but actually By the time you factor in dip and fly spray and this, that, and the next thing, you're looking at spending 9. You know, in terms of advertising, Georgia, you're in marketing. Do you advertise your livery at 9? Or do you say $6,000 plus extras?
Yeah.
So it's really important when you conclude that contract that you know what those extras are. Are you going to get charged when the groom lunges the horse? Are you going to get charged if the blanket needs to be repaired and the person has to drive the blanket to the tailor to be repaired? All of those things need to be spelled out in a livery contract. And in particular, things which are important to you. So for me, turnout matters. I don't want to be in a yard where my horse is stabled for too long. I like my horses out by 9. I like them in by 4. If that is what you want, you need to specify that in your contract, because you can't then complain when you arrive. And are you the kind of client who says, well, my horse has a rain rug, so I don't care if it's raining? Then you know, again, some of this is law, some of it is communication. How fair is it for you to insist that your horse gets turned out in a bog and every single other horse is stabled, and now the yard owner's got to deal with your horse yelling his head off?
Exactly. And then your horse slips and then it injures itself. And so one of the best sorry.
So a lot of having horses in livery is accepting that you're going to have to respect the yard owner's discretion in certain things. So if there are certain things which are non-negotiable for you, those should be in the contract.
Okay.
And if they're not in the contract, you kind of have to trust the yard owner to make the right decision. And if you think the yard owner is not making the right decision, then you find another yard.
I have to tell you, one of the best livery contracts I've seen was almost like, I don't know if you've been to Rockamama's and you have to build a burger and they give you a list of everything. And it was incredible. And they were very upfront about it. This was their basic livery, but they said platting for shows. I mean, it wasn't quite ridiculous, but it was like, if you want your horse to come in to eat lunch, you know, that's an extra staff member we're going to need, you know, it's going to cost this amount a month. And so I think, and Tracey, I think if we can normalize yards doing that, it'll also just become easier for you to go in with that. This is my livery price, not the lower price, excluding extras. And, you know, like you said.
And I think it also educates owners, because I think there's a lot of owners who really don't understand what goes into keeping a horse.
Yeah.
And I say this with all respect to them, because I think there are 0.001% of owners who don't care. The rest, there are things they don't think about.
It's just,
they don't
know what you don't know.
Yeah. Yeah, this March and April, my grooms get paid extra because I can't put my horses into blankets at 4 o'clock. So they go into this blanket, and then at 6 o'clock it gets changed, because I don't want them sweating, because then I've got to feed them more because they're losing weight. So my guys are working a little bit later. And that swapping of blankets is something a yard owner has to think about.
To factor in.
And somebody's doing that job. Who's paying for that? And it doesn't get thought about. It's not really considered. And I think if we can have contracts like the one you've mentioned, we're actually doing owners a favor by making them more aware of exactly what it takes to keep their horses.
I think we're very spoiled. I mean, you and I have also discussed this on the Grooms podcast with Candice Hobday. We're very spoiled by the labor that we have at our fingertips in South Africa. And it enables a whole bunch of people to own horses and enjoy the privilege of owning a horse without perhaps getting to know the ins and outs of horsemanship or care, to your point. Tracey, 2 interesting questions. I think tying in with our previous section, if a recorded conversation is recorded without the other party's knowledge, is it legally usable?
Yebo.
Okay.
We're a one-party consent state. I don't care what the banks tell you in their little messages at the beginning. I record every single telephone conversation which comes to me, because I'm too lazy to write telephone notes.
Okay, that's interesting.
And you don't require the other party's consent to make a recording.
And then the second question, which someone has asked, is Oh, sorry, I've just almost lost it. Oh, interesting. Can a horse be dispersed to cover costs for a livery that has defaulted on payment?
No. And we see this all the time. And it's one of my very favorite things to do, is to tell people, well, you can't do that. A horse is an asset. Even a bank that has financed a vehicle cannot sell that vehicle without a judgment.
Okay.
So if you have a horse in your yard, you cannot, just because the person owes you money, sell the horse to recoup your money. You have to sue them. You have to take judgment. You have to attach that horse, and you have to sell the horse to the sheriff. And good luck to you, because it will go for meat value. So if somebody owes you livery and you want to recoup your money, my advice to all of my clients is, for all that's holy, bring an application to attach the tack and give them back the horse, because horses just cost money for every month that goes past.
It was literally coming in hot and heavy as you were saying that. They were saying, can they surrender the horse if they're, as the yard, incurring a monthly cost looking after the horse?
Can who surrender the horse? The yard. To whom? To the horse care unit?
I would assume so, Tracey. There isn't another part to that, unfortunately.
I've had this.
Some owners, we've gone before, and you just can't get hold of them.
No, this is interesting, because I think the argument can be made that the owner is neglecting the horse. Okay. I don't know what the horse care unit's attitude is. That you would have to ask them, because it's up to them whether they accept the horse being surrendered. But I think that if an owner has absconded, or if the owner is refusing to pay, that the yard owner could call on the SPCA or the horse care unit or any animal welfare institution which is tasked with dealing with animal neglect to take the horse in. Where it gets tricky, and I've had this, is where the ownership of the horse is in dispute, and suddenly the yard owner is left with this animal and nobody is paying for the animal, and the yard owner is going, well, it's not my problem, which it clearly isn't. But the horse care unit in that instance said, we're not prepared to surrender the horse, because it would be inappropriate for them to involve themselves in that situation. In that instance, the appropriate remedy is for the yard owner to institute what's called interpleader proceedings, where they approach a court and they say to the court, I am this innocent little third party. I don't know who owns this animal. These are the two people claiming the animal. I want the court to issue a summons, and I want these two people to come to court and get a ruling. And they can, in that instance, ask that the court order the successful party to pay their costs, including the cost of keeping the horse.
Okay, thanks, Tracey.
No problem.
Okay, moving on, unless there's anything else you want to add to that, to lease agreements.
Yeah, you also can't just sell saddles and bridles either.
Oh, okay.
You can't sell stuff without a judgment.
Oh, okay. Okay, even if
and the sheriff has to do it. Yeah, the sheriff is the only one allowed to do this stuff.
Jeez, as you say, good luck with that.
Yeah.
In a lease agreement, and a lease agreement would be also called baiting a horse. Obviously, you're now not purchasing a horse from the owner; you are renting it, essentially, I suppose. Why is a lease? I mean, I outlined this before. You basically just drummed contracts into me. But why is a lease agreement a good idea in this situation? Because these lease agreements do tend to be very friendly.
Look, there's a lot of advantages to a lease agreement, I think, especially for ponies. Kids outgrow ponies hell of a quickly. And to buy a pony and then go through the heartache in 2 years' time of having to sell the pony so that you can buy another pony that you can cry about in 2 more years, it starts becoming better to lease. Yeah. It's also, I think, advisable for a person new to the sport, before they commit to buying a horse, to lease so that they can be absolutely sure that their lifestyle suits the sport, that they can pay the costs,
That
which
they
they
want
often
to
don't
do
think
for
about.
sport.
Yeah. So there's a lot of advantages to a lease. I think it's also, for the owner of the horse, it can be a useful way to keep an animal that they don't want to give up, but at this particular stage of their life, they cannot ride. They're pregnant or they're at varsity or whatever. So there's many reasons why a lease is a good idea. But whether this particular lease is a good idea is going to depend on the parties involved and the terms of that lease. I have leased horses. I have leased horses out. I have only ever had one bad experience. And I think, like most things, contracts make for good friends. So when both parties understand what the terms of the lease are, then it works. And I think if you're going to have a lease agreement, especially if it's a lease at the yard where the owner, if the owner is insisting that the horse be at the yard, it's possibly a good idea that the yard owner is involved. Okay. Because they're obviously responsible for caring for the horse. So I think it's quite important that the yard owner get included in whatever agreement is made. And if there's a home lease, you probably want a clause allowing the owner to inspect or be allowed to have access to pictures and that sort of thing, just to check on the horse.
So a question that was sent to me before the podcast, actually, Tracey, was somebody saying, is there a way for the law to determine what cost for the horse lies with which party? And they were speaking specifically to veterinary costs and similar incurred while the horse is being ridden by someone who's not the owner. So, for example, if a horse had to do, the specific example that they used was, if the horse does a suspensory due to the work that it is doing, who is responsible for the rehabilitation of this injury?
It's very difficult to answer because I'm not sure what the relationship is. So I'm going to presume in this context that the horse is being leased out, and during the course of the lease, it does a suspensory. What do the terms of the lease say? Most lease agreements stipulate that the lessee, the person who's leasing the horse, is liable for all the costs associated with that horse's care. And that would include any veterinary costs associated with the horse's care. I have seen some where part and parcel of the lease agreement is that the lessee takes out insurance for the horse and medical aid. And I think that's not a bad idea.
Yeah.
It's quite a good idea to have that, because then this argument becomes a non-issue. The one thing you've got to be careful of is that these lease agreements are often month to month. So if a horse does a suspensory while the lessee is liable for the veterinary costs for the duration of the lease, that lessee may go, oh, well, suspensory, terminating the lease. And from the date of termination of the lease, they could argue that they're not liable. Then you would have to start considering whether the lessee was negligent in caring for the horse, and as a result of that, that negligence caused damage. That becomes very, very difficult to prove.
Hugely difficult. I suppose maybe another thing you could include in your lease agreement is a reasonable termination period. So 3 months or 6 months, or, unless it's subject to some, whatever the extenuating circumstances are. But Tracey, the more you talk about contracts, the more I think the biggest thing is the contract just sets the playing field, perhaps, for us to have these awkward conversations, perhaps with friends or people who we respect. So once you've discussed, well, worst case scenario, like, I love your horse, I'm leasing it, I'm paying money, but it has an unrelated second colic op, God forbid, it's already had one colic op perhaps earlier on in its life. I don't think I should be liable for that. You're going to say that and I think just it brings all of these conversations that we don't always want to think about to the forefront, perhaps. And that's
and it provides a space for you to look for answers that work. So you could for instance say, actually, I didn't think about colic. The horse is insured. Will you take over the insurance? there's various ways, but if you can't talk to somebody before you've concluded the contract, you're not going to talk to them when trouble happens during the contract. It's just not going to happen.
True. Well, I liked what you
Then
said.
walk away.
If you're, even if you're married to somebody, you have to have those awkward conversations. And if you can't, you need to rethink that relationship.
Yeah. And it's okay. It's okay to, I've negotiated contracts with people which at the end of the day have not been signed. And the people have walked away, and there's often a little bit of hurt feeling. And I've said to both parties, you know what? The fact that you can't conclude a business arrangement doesn't mean you can't go for a drink. It doesn't mean you're bad people. It just means you're not the right people to be in this relationship together. And that's okay. It's actually okay. Then find somebody that you can be in the relationship with, because they're out there.
Yeah. So moving on to the final segment of our legal eagle discussion, public liability. So first of all, what does public liability mean, Tracey?
Okay, so it is the liability of a person for damage caused to a member of the public. And it arises in our context in a couple of instances. Firstly, you're a yard owner and somebody comes to the yard and a horse breaks loose and kicks their car. You were the person responsible for the horse at the time. Are you responsible for the damage to the car? That's why yard owners should have public liability insurance, so that just never becomes an issue. It also comes up at shows. I've seen some rather amusing incidents of people deciding to park their very fancy Mercedes-Benzes right next to a horse truck and then being perplexed when there's a hoof-shaped dent in the door. And who is responsible for that? Is it the show venue? Is it the owner of the horse? Is it the yard whose groom was holding the horse? So basically, it's the liability of somebody to a member of the public. And the question of who that is arises in different contexts, but it makes most homeowners insurance comes with public liability insurance. So I think people should all check their policies. I think horse insurance comes with public liability, if I'm not mistaken. I'm one of those dreadful people who doesn't have horse insurance, but I do think that it does come with public liability, and I would encourage people to take it out, because if your horse causes damage to somebody, regardless of whether or not you're negligent, our courts are going to make you pay because it's a no-fault liability.
One of the questions that I got about public liability was from a client who wanted to know specifically about stallion owners, if they're not obliged to have public liability. And I know we speak about all horses, to be fair. I think stallions, obviously, if you've had a stallion, they can be more of a liability to life in general. But the questions were for an incident between two horses on a show holding ground. But she wanted to know, secondly, if that horse had to get loose in public property, so I assume on like an outride, and then incurred, like, what is the liability in that situation?
Okay, well, we have this thing in our law called the Pauperian action, which says that if an animal does something which causes damage to another person or another animal, the owner of the animal which causes the damage is liable for that damage, regardless of whether the owner was in control of the animal at the time, regardless of whether the owner took all steps to prevent it, because, as I said, it's a no-fault. It's an old Roman law remedy, and basically it says, you want to own an animal, suck it up, you're liable.
I like that. That's a very succinct interpretation of the law, Tracey. I appreciate that.
Yeah.
We did have a situation a few years ago at a showground where the showground was called up for mismanaging some of the classes, basically, and which resulted in two horses that shouldn't have been exposed to one another having an altercation that resulted in one of the horses being injured. I'm just trying to understand here. So you would have to take on the owner of the other horse and then the show holding body separately. It's not an either or situation.
Oy. I'm trying to understand when we have horses who shouldn't be exposed to one another.
No, so it was basically there was a clash into, as soon as I say it, I'm worried everybody's going to know what I'm talking about. So it was basically just two classes that should never have coincided. To give an alliteration, we a parallel example, we could say it was a stallion class and a mare class right after one another.
Oh, okay.
You know, so and the showground had mistimed it, and basically the stallions and the mares came out at the same time, and one of the stallions kicked a mare and ended her career. So the stallion owner was called up for this, but the stallion owner then tried to defer, not blame, but say that the show holding body was also responsible.
Okay, so in terms of that Roman law remedy, the stallion owner is responsible to the owner of the mare. That doesn't mean that the stallion owner can't hold the show holding body responsible if their negligence contributed to the incident. So, the law sometimes does that. It says, well, in contract, you're liable, but you can recover some of your liability from somebody through delict. And I think that this would be one of those instances. I know that the showgrounds are famous for indemnity clauses and going, we are not liable for anything, but it's not as simple as that. No. If you make your money inviting people to bring their horses to your showground, you are implicitly saying that my venue is safe and your horses will be cared for, and we will do everything we can to prevent things happening. And again, I don't
agreements, between parties that if you're a dealer, you assume to know these things and so on and so forth.
Contracts will cover you so far, but there's principles of public policy involved as well. So we see it with, I used to do a lot of work for insurance companies, and I used to represent them where they acted on
very bad in your life that you've landed up.
I represented all of them, but a little old lady would walk into a store and somebody would have spilt oil like 5 minutes before, and she would slip in it, and as little old ladies do, they shatter things, and she would sue the store, and the store would go, but we didn't spill it. And the court's general approach, and still is that, well, you kind of said that it would be safe for her to come to the store, so you have to put systems in place to prevent this happening, and if you don't, or if those systems fail, then we may hold you liable. And I think the show venues are going to be subject to the same sort of thing. They're all going to love me after this.
Yeah, you'll never be able to enter another show again, Tracey. That's how small I am. Tracey, last question about public liability to conclude this evening is, and I don't know if public liability is technically the correct phrasing for this, but for coaches and public liability. It is becoming a discussion now with the Coaches Commission, coming more forcefully into being. What kind of liability can coaches expect, to be held against them in the next few years?
Look, I don't know what the legislation is, and I don't know what the Coaches Commission is doing. So I'm just going to talk in general principles, because as far as I know, there's no special legislation governing this. But as a general principle, if you offer a service to somebody, the implication is that you are a careful and diligent service provider, and that you will take all necessary steps to perform that service safely and well. So as long as the coach has done all of that, I'm not sure that they can be found liable for an incident where somebody is hurt. It's an inherently dangerous sport. If a coach overfaces a horse and overfaces a child, or has people riding in an unsafe area, or jumping unsafe obstacles, or puts a kid on a horse that the child is not ready for. That is the coach not complying with their duties to provide a safe and proper service. And I think then, just as you could sue a plumber who screwed up the plumbing, you could sue a coach who caused damage. I think that, those principles are fairly general. Do we have time for one thing that we didn't talk about with contracts?
Absolutely, please.
Notice is something which comes up often, especially in liveries. I get phone calls from people going, oh, so-and-so has cancelled their contract and they're moving their horse tomorrow, and I want to keep it until they pay me notice. You can't do that. The only time you can refuse to release a horse from your care is if the person who owns the horse owes you money, because you then have a lien. Just like a mechanic who fixes your car doesn't have to give it to you until you've paid him, you don't have to give the horse to the person until they have paid you what they owe. Notice is not owed yet because you haven't rendered the service. So it's really important to put a clause in your livery contract as to what the notice period is. And generally, if there's no particular period, our courts will say it's month to month.
Okay.
And what I would advise livery yards, if this is a problem, is instead of trying to hang on to a horse for an extra month, is just ask for 1 month's deposit. That's the easiest way to avoid people flitting away in the middle of the night.
Yeah, I think
and equally, if you give a notice and you want to leave, the person can't keep your horse.
So it frees up all parties. I think also the benefit of that that 1 month livery, and I say this is, I have so many friends who own yards, and it's hard. It's hard for yard owners as hard as it is for owners of horses to leave their precious animal in the care of someone. But they often say, if someone falls into arrears for 1 month, it's very seldom that they can then make up 2 months. So having that 1 month deposit in your pocket gives you 30 days to assess the situation without losing money. And to then on the 28th or 29th of the month to say, guys, you're going to have to take this, you have to leave,
and also to sometimes salvage relationships, because things do happen. Somebody has a massive bill that was they were completely unprepared for, and they say, listen, I'll replenish my deposit at the end of that month. It gives you the opportunity to do that. Yards that are so reliant on livery that they can't afford to let a horse go probably shouldn't be operating.
I think the capital required to run a yard is enormous, Tracey, and it's maybe a separate discussion, because we were even talking about how they have to stockpile for grass when it's winter, and that requires often an upfront vast payment from livery yards. But maybe just that livery yards need to, sometimes we all think we want to have our dream, and we want to go and run a livery yard without sometimes understanding the implications, specifically financial of that. Tracey,
it's a big black hole.
Is there anything else you would like to add to that? I could speak to you and pick your brain. It's great.
I just want to say to anyone listening that lawyers have this terrible reputation, and we deserve it. You want to avoid at all costs having legal battles, and the best way to avoid a legal battle is to go to a lawyer before you're in cuck. So it's a lot cheaper to engage the services of an attorney to draft an agreement than to engage the services of an attorney to litigate over one. I would love if somebody could speak to SAEF. I think if SAEF could put up some template contracts on their website, livery agreements.
Tracey,
it would be
something we've spoken about.
Yeah, it would be, even if it's not a template contract, just a list of things that people should consider and agree on. It would be really, really helpful. And then again, consider mediation if you are in a dispute. And it's essentially what we get involved when people stop being able to talk to each other. And I think the longer you can talk to each other like human beings, the less often you need a lawyer.
And I
Says
think
the person who swears like a fish life.
Yeah, I think a contract just helps to circumvent that completely, Tracey. And like you say, it's actually a bit of a saving grace if you've got two people who sit over a contract, can't sign it, and they part before any of that animosity gets to take place, hopefully.
Yes,
You know,
and keep it simple. Make sure that whatever the agreement is completely unambiguous. You know, you don't need to use words like heretofore, wheretofore, and party of the first part and all that. You don't. You need a really simple agreement that everybody understands.
yeah. Tracey, thank you so much for your time tonight. I'm sure we're going to be speaking to you again in the future at some point, hopefully on this forum and not in a mediation room.
Thanks, Georgie. Have a lucky evening. Okay, bye.
If you've just joined us, we were speaking to lawyer Tracey Lomax about clarifying your contracts when it comes to equestrians, to liveries, to lease agreements, and discussing public liability and sales. What everybody needs to be aware of. Highly recommend watching that. If you've just joined in, it will be up on our YouTube channel along with our many other very wonderful podcasts. Tracey, of course, also discussed grooms contracts with us earlier on in the year with Candice Hobday. And there was also a veterinary podcast on buying and selling horses to help everyone along to resolve these tricky issues. We'll be back next week where we're hopefully going to be discussing trucking your own horse. We did discuss transporting your horses long distances on floats. We're now going to be taking a look at the two berths that most equestrians use. So be sure to join us here again next week at 7 p.m.